Welcome to the Greater Zion Law Podcast.
Welcome to the Greater Zion Law Podcast with attorney Travis R. Christiansen. Travis is a Southern Utah attorney who helps individuals and families protect what they've built through practical estate planning designed to avoid confusion, conflict, and unnecessary legal problems down the road. I'm Lisa Mosbey, and today we're talking about incapacity planning in Utah and how families can avoid unnecessary stress, disagreements, and legal complications when someone can no longer make decisions for themselves. Thanks for joining me for this conversation, Travis. It's a tough one because we're talking about our loved ones and helping them make those decisions.
It is. It's a tough one, but it's one of those things that, estate planning really can be one of the last great acts of love that somebody performs for their kids and their descendants, because the goal really of estate planning is twofold: to make it a very smooth transition from a legal standpoint, but also to make it a smooth transition emotionally and to avoid conflict and just get things in place so that when you pass on or you lose your marbles, whatever happens, or when both happen, that your family's not having to spend a bunch of money and time and stress in court, that they can do the important stuff of being, by your side, with each other, mourning and helping and doing those more important things rather than spend a lot of time in a guy like me's office. So,
And I know we all need it, but honestly, I think there's certain situations that lead families to realizing that they need incapacity planning. How do you identify that? When should they do it?
before they lose their marbles, because
Absolutely.
yeah, and here's the challenging thing that I have happened so often, and I have these people that come in and say, hey, my mom's in the hospital, my dad's in the hospital, and they've got Alzheimer's and dementia, and I need to be able to make these medical decisions. Can you come to the hospital? And they can sign some powers of attorney or, a living will advance directive document. And I have to tell them, I'm sorry, but no, because if they've got Alzheimer's and dementia, it's too late.
It's too late.
Because for someone to create a legally binding estate planning document, they have to have what's called testamentary capacity. And it's a big legal word that basically means that they know basically what they have in life and who the natural objects of their affection are. And so it's a tricky thing, but the sooner the better, quite honestly, especially if you've still got your wits about you. Come in and let's get that planning done, because once those diagnoses come of Alzheimer's, dementia, you, heaven forbid, you have a stroke unexpectedly, and now you can't speak for yourself, and somebody's got to be able to. And the way family dynamics change so much anymore with divorce and second and third marriages and situations where, people don't get married, but they cohabit and live together for decades quite at times because of various reasons. It makes financial sense to not enter into that second marriage, but you get in these long-term relationships, and protecting each other even in those can be a reason to get these kind of things in place ahead of time, because again, you want to avoid the fight.
So, Travis, what legal documents allow someone else to step in and handle financial or even medical decisions if a person can no longer make those decisions themselves?
So there's two documents. One is called a durable power of attorney. It's the legal document that gives someone the ability to act as if they were you in all financial and business matters. And the second document has multiple names, sometimes called a living will, advance directive, healthcare power of attorney. And that document allows someone to make medical decisions for you, and it sets the rules for those medical decisions. That advance directive living will document is often referred to as the pull the plug document, or the DNR, do not resuscitate, is another common word that's used for those documents. So those are the two main documents that are created and what their purposes are.
And then what practical problems can families run into when nobody has legal authority to access accounts, manage finances, or make medical decisions?
I'll give you a great example that what the practical problem they run into is a lot of expense coming out of their own pockets. That's the practical problem, because what happens, and I've got one right now, is they're trying to access their mother's home equity, but mom didn't do the plan, and mom needs care. So they're trying to take care of some of that kind of stuff, and they're having to come out of pocket. I've had situations where the family has had to dip into their own money to pay for their care of their loved one because they can't get in their loved one's bank account to pay those expenses. The money's there. Now, it's a temporary problem, right? But, let's face it, most people are living almost month to month. Their expenses meet their income. And so if all of a sudden, you've got to come up with, between you and two or three, four siblings, $1,000 a month, $2,000, $3,000 a month to pay for some medical bills for mom or your dad, and there's $500,000 or $1 million sitting in their investment accounts, and you can't get to it. So then you got to go to court. You got to say, hey, judge, my mom or dad lost their marbles. I need to be appointed their conservator so I can go get the money. Well, now that brings another problem. Who's going to be the conservator if they haven't named it, right? And so now you're going into court and you're saying, hey, I need to be the conservator. I'm the oldest. And then your younger sibling says, yeah, but you're a drug addict. You're just going to go blow it on methamphetamine, heroin, or crack. So now what's going to happen, right? And then the youngest, you're like, well, you're an idiot because you're the youngest and you've never known how to. There's money magnifies personalities. And so if you're a good person, you're going to be able to do more good with your money. But if you're a knucklehead, it brings out the worst in people. It really does. And so those documents prevent those fights, and they prevent your family having to come out of their own wallet and pocket to pay for your expenses until they can get into that judge to give them access to those accounts. And so, and on the accounting, the typical document, again, is a durable power of attorney. Well, some people say, well, gee, I don't want to give my kid access to my bank accounts right now. That's stupid. You're right. I agree with you. You shouldn't do it right now. And so there's two ways you can set up that power of attorney. One is an immediate power. I'll give you an example in my own life. I've got one of my daughters who's going to be leaving the country for 18 months. She's an adult. She's doing some church service, and she's got a bank account. We need to be able to maybe do some things for her while she's gone. So we did an immediate power of attorney that expires the day she gets back in the United States. So that while she's gone, my wife can access her bank accounts, can renew driver's licenses if that comes up, can do all of those kind of things on behalf of my daughter while she's gone. That's an immediate power, but it's going to sunset. So I don't like immediate powers because I've actually seen people use those to plan a divorce 3, 4, 5 years ahead of time. So my preference is what's called a springing power of attorney. And what that is it's just how they act just like it's described. It's spring. So you basically set the conditions, and they're spring, and they're dormant. The spring is squished, compressed, if you will. And then when the conditions are met, it springs into being. And if those conditions go away, it goes away. And so I had a cousin had a stroke at 50. And so his springing power of attorney kicks in. Now his wife can make all his decisions and handle all that kind of stuff. And then once he recovers from his stroke and regains his ability to function, it went away. That's how a springing power works. And so if you've created one of these, once you get that Alzheimer's, dementia, or other diagnosis where you just can't manage your own affairs, once you get a couple of doctors to say that, guess what? That power now can be used by your family, but not until then. And you can set other conditions. I have some clients that like to travel the world. And so they've put in their springing powers of attorney. If they're ever out of the United States for 14 days, on day 15, it springs into being. And this actually came in very handy about 8 years ago. I had some clients who did this springing power, and they went on repositioning cruises. When it's a long cruise, maybe the cruise ships are leaving, the Caribbean, and they're going to go down around the Horn of South America and up to Alaska. Month-long cruise. They're gone. There's a late freeze at their house, and their pipes break, floods their basement. The alarm system goes off. Hey, we got water, et cetera, et cetera. Because they had that springing power in place that said, because they knew they were going to be taking these long trips. If we're ever out of the country for more than 14 days, our kids, they nominated one of their kids that lives locally to act as if they were them, gave them that power of attorney. So that child was able to get in, get in their home, hire the restoration people, hire the drywall guys, hire the plumbers, hire all the people that were necessary to come in and fix that house so that when mom and dad got back from their cruise, it was as if nothing happened. Can you imagine if they had not done that, right? To come back, I mean, in an emergency situation, the kid's probably going to break a window and shut the water off. But legally, unless they can come out of their own pocket, they can't do anything to fix that property. And it'd be trespassing because contractors aren't going to do work for somebody that doesn't own the property, right? And so it's that's one you'd never think of, but it's something that if you're traveling, and so we have these conversations with our clients to make sure these documents are there, because in a way they weren't incapacitated in the normal sense, but they were logistically incapacitated. They're on a cruise ship down around the Cape of South America. They don't have cell service. Internet's spotty. I haven't done a cruise, but people tell me the internet on cruise ships is crazy expensive. So so it was really good that this, anyway, it's just one of those places where prior planning prevents problems. And so we have these conversations with our clients. We ask them, do you plan on traveling? Do you plan on serving church missions, whether it's, somewhere where you're not going to be around? Can we put things in place to make sure that while you're gone, things are okay? And that somebody has the authority to step in either later on if your incapacity kicks in, or one of these circumstances when you're out of the area and just need somebody to take care of something.
Wow, that is a big one, and I'm curious. How do we choose that right person to handle our financial and healthcare decisions on our behalf? Many folks have children, or you have siblings. Um, who do you pick? How do you decide? What's the process to go through?
This is how I typically will explain it to people. Your child with the most compassion needs to have your healthcare power of attorney, your advanced directive decision ability, because you want the one that's going to have that compassion. I recently heard a story where the dad was in a ton of pain. He was ready to go. And one of the siblings, they didn't have a plan. And one of the siblings insisted on waiting, I think it was 3 days, for one of their kids to be able to get there to say goodbye to grandpa before they would all unanimously say, okay, we can pull the plug. So you want the person that's going to be the most compassionate, who's willing to swallow their own needs and wants of keeping you around. Or maybe you want the one that's the most cold-hearted. I don't know. But you want the one that's most compassionate toward you, that's willing to set aside their own desire to keep their mom or dad around and say, you know what, it's time to let them return to their Father in heaven and enjoy that next phase of our existence. And so that's who I suggest for that healthcare power of attorney. Now, the financial power of attorney, the durable power of attorney, really, to me, it's going to be the one that's most business savvy, and that the rest of the siblings are going to respect and trust, not to get caught with their hand in the cookie jar. That's going to be able to make those decisions to fix the house, to sell it in a smart way, to do those things that need to be done. If there are investment things, that can understand what the investment guy is talking about if they talk about concepts like beta or, net return, and you can get into a lot of that. But so those are the two. The most compassionate for the healthcare is my typical recommendation, and the one with the business savvy and or the respect of the rest of the siblings to be able to make those decisions without it creating a fight.
And Travis, here's the monkey wrench. What if you have a blended family or a second marriage? How does that change incapacity planning for folks?
And that can be really interesting. And the reason is you've got two problems with this. Number one, you've got the gold digger problem. And I won't go into that a lot. And then the other problem you've got is the one where it is a multiple decade second marriage, right? Where, I had a situation, this was hard. And I may have mentioned this before, but in this context, it's where this future planning becomes important with blended families, is two people had each lost their spouses to cancer in their late 40s. And they remarried 5-6 years later, and they're now in their mid 80s. They had been married for 30 years. And yet this couple had not done any planning on the blended family situation. And upon the death of the husband in that situation, the husband's kids kicked their stepmom of 30 years out of the house with a week's notice. And so if you're in that blended family situation, you want to have some planning done, but I would caution on the gold digger thing and be aware that that is a real thing. I actually had that situation. We just got court orders on last week where my client had remarried a guy that was 20 years her senior and brought her into my office 3 years ago to have her change her estate plan to give him everything. And after 2 minutes of talking to her, I can tell she lacked testamentary capacity. And then we heard through the grapevine in the care center that he was taking her around to law firm after law firm, trying to find an attorney that wouldn't see what was going on to change what that estate plan was, which was to give him a temporary life, the ability to live in her home until he passed away or remarried or cohabited, but everything else went to her kids. And he was trying to change that. And so, again, second marriage situations, early on in the marriage, if you're concerned, my recommendation for second marriage is you really need to do a trust and an estate plan of his, hers, and an ours. You almost need 3 trusts, 3 plans, where the stuff that he brought into the marriage is going to go to his kids. The stuff she brought into the marriage is going to go to her kids. But we also do some middle road planning of maybe that life estate issue that, look, if whoever dies first, the other can live in the house we've been living in for the rest of their life, as long as they don't remarry or cohabit, and then that house will be divided in the way it should be based on who had that, maybe that asset coming into the marriage. So second marriages complicate things, and that's where gold digger, and then just they can last a long time, and these people, their life become intermixed, and then you have kids that start fighting because, again, money can magnify a personality, and all of a sudden you've got some of your kids that maybe are on the edge of insolvency and filing bankruptcy, but all of a sudden they inherit $30,000 from mom or dad, and they're out of debt, and they can breathe at night and not be worried about the bill collector calling. So it's these are important. I mean, estate planning hits at the heart. It hits at the fundamental basic human nature of love and taking care of our families and making sure things are okay and avoiding those problems. And so, yeah, second marriages are some of the most important estate planning things you can do, and also some of the most complex, because maybe you're early on in a second marriage, you don't want to give that person the ability to make those medical decisions for you. You're not quite sure. You love them, it's all great, but maybe you haven't had those deep conversations. So maybe that stays with one of your kids. But hey, maybe 10, 15 years in, you're like, I think this person's going to be a lot more compassionate than my kid, so I'm going to change it. And that's okay. But just make sure that it's in place, that people know about it, so we don't have those fights and we can avoid the conflict down the road.
Travis, I want to give you one more opportunity to wrap this all up for folks. There's some key takeaways that you've shared today. Planning is best. Don't wait till it's too late. We want to spend time with our loved ones. And there's several documents that you mentioned that are, very important. It's not just one or two. And this is not a one size fits all. We have to sit with somebody who can walk us through the right questions to ask to get our plan set up. Do you have any final thoughts for our audience today?
Don't wait. If you're worried about estate planning, if it's crossed your mind at all, come see us, because the worst thing is what I had happen last week. They came in, their mom was in the hospital, and they said, "Can we do these things?" No, sorry, she's got an Alzheimer's diagnosis. I legally can't do anything. Well, what do we do? We got to go to court, guys. And instead of costing like 2 or 3,000, this is a cost 7 or 8,000, because we've got to go to court. You've already told me that your cousin Bill or your brother Bill is going to fight everything because he thinks mom told him this. Well, what mom said doesn't matter. It's what's on the written documents. And so avoid those fights for your family. It's a great expression of love, really, to get your estate planning done, to get it in place while you've still got your wits about you, while you know what you're doing, because once you are incapacitated, it's too late. And now your family's going to end up in court, maybe fighting and duking it out over who should be in charge of letting mom or dad die. Can you imagine having that fight? But kids have that fight. And so let's not have your kids have that fight. Come on in, let's get that sorted.
Yeah, many families have estrangement issues in them because of this exact reason. So you've really driven it home for us today. Thank you so much for your guidance through this challenging process.
Thank you.
That's it for today's episode of the Greater Zion Law Podcast with Travis R. Christiansen. If you'd like to learn more about incapacity planning in Utah or put the right documents in place for your family, visit greaterzionlaw.com. And thank you so much for listening. Don't forget to subscribe, leave us a review, and come on back next time. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.